5 seconds to go. Start. We are not at all impressed with the submission canvassed on behalf of the respondent that even if there are contradictions or discrepancies in the documentary evidence of record, there is not a single date emerging on record on the basis of which it could be said that the respondent was major on the date of the alleged offence. Stop. It is a very unreasonable argument. Stop. That is not the correct way of looking at the core issue. Stop. The correct way of looking at the core issue is to closely examine whether there is any cogent or convincing evidence as regards the correct date of birth of the respondent accused, and after ascertaining the same, reach to an appropriate conclusion. Stop. If, there is any doubt in this regard, there is no good reason why the matter should not be referred to a duly constituted medical board which shall, in turn, record its findings and submit to the Juvenile Justice Board. Stop. The word may should be read as shall, having regard to the very object of sub rule 3 of rule 74. Stop. Para. It is a well settled principle of interpretation that the word may, when used in a legislation by itself, does not connote a directory meaning. Stop. If in a particular case, in the interests of equity and justice, it appears to the court that the intent of the legislature is to convey a statutory duty, then the use of the word may will not prevent the court from giving it a mandatory color. Stop. This court in Bachchan Devi versus Nagar Nigam, Gorakhpur reported in 2008-12 SCC 372, held as under, para. It is well settled that the use of the word may in a statutory provision would not by itself show that the provision is directory in nature. Stop. In some cases, the legislature may use the word may as a matter of pure conventional courtesy and yet intend a mandatory force. Stop. In order, therefore, to interpret the legal import of the word may, the court has to consider various factors, namely, the object and the scheme of the act, the context and the background against which the words have been used, the purpose and the advantages sought to be achieved by the use of this word, and the like. Stop. It is equally well settled that where the word may involves a discretion coupled with an obligation, or where it confers a positive benefit to a general class of subjects in a utility act, or where the court advances a remedy and suppresses the mischief, or where giving the words directory significance would defeat the very object of the act, the word may should be interpreted to convey a mandatory force. Stop. As a general rule, the word may is permissive and operative to confer discretion, and especially so, where it is used in juxtaposition to the word shall, which ordinarily is imperative as it imposes a duty. Stop. Cases, however, are not wanting where the words may, shall and must are used interchangeably. Stop. In order to find out whether these words are being used in a directory or in a mandatory sense, the intent of the legislature should be looked into along with the pertinent circumstances. Stop.